Yes, good evening, members. So today I decided that to avoid a situation where students are cramming about types of limited grants and their applicability in Kenya, I decided to do a publication on the same, and this publication was done in 2023. And this publication is important because it has encompassed various decisions in Kenya that will help us debunk some theories where students usually have conflicting take when it comes to understanding these limited grants. So basically, I've said that this week will be a marathon because we'll be narrowing down to various key legal principles, discussing them in details, and making sure that we have understood the practical element of the same, so that we will have covered as much as possible before orals and before the main examinations. Our rule still stands on doing past papers. That will resume with speed. But for now, we want to understand various legal principles. Okay, so I'll begin through skimming through the document, highlighting the key elements arising from the same. So the document is visible before you, and I'll start by saying that there are two forms of grants that are provided under Section 53 of the Law Succession Act, where we have grant of probate and grant of letters of administration. Okay, then you should note that grant of letters of administration are further classified into grants of letters of administration with will annexed and grants of simple administration. Okay, the other thing that you can take away from this publication is that a grant of representation is therefore needed to administer the estate of a deceased person, while on the other hand, a limited grant is a grant that does not give the personal representative authority or confirm the authority in the case of a grant of probate. So that is where we have a will to act with respect to the whole estate in all respects until the administration is completed. Section 54 of the Law of Succession Act allows the court to limit a grant of representation that it has jurisdiction to make. Then you should take note that a grant may be limited as to special purpose or property or time, or it may be one or more various special types. In addition, Section 54 and 55 of the Law of Succession Act provisions are very clear that a limited grant is normally issued due to exigencies arising in relation to the estate. The advocates, okay, who had applications for to submit, I've skipped some pages, to the estate. Okay, so it is usually issued without prejudice to the right of any other person to apply for full grant of representation to the deceased. And as such, limited grant may not be subjected to full and strict compliance with the requirements meant for, as if it is a full grant of representation. Okay, so this article discusses each class in details. So the various types and classes of limited grants have been set out in Schedule 5 to the Law of Succession Act. However, you should note that this is not a straightforward solution, as the courts had further sought clarification, as was seen in the case of matter of the estate of Banji 2000, where Justice Angawa was forced to request from about 30 advocates who had applications for limited grants pending before him to submit to him on the following points. the purpose of limited grants, types of limited grants that exist, and the procedure to be used when applying for the same. Okay. So those points were vital as applicants will pray for limited grant by invoking either Section 54 or 67 or Rule 36. There never was one uniform prayer for coming into court for a limited grant. The court held that the procedure in coming to court by limited grant be by way of petition and an affidavit. In addition, the 5th schedule to the Law of Succession Act is authoritative to the different types of limited grant there exist, and that only 2 categories of grants will exist. Grants limited as to purpose. So this is provided under paragraph 11 and 12 of the 5th schedule. There are several types of grants that are each limited as to purpose in different ways. We have grant ad colligenda bona. In Kenya, the limited grant ad colligenda bona is provided for under Section 67 of the Law of Succession Act and Rule 36 and 37 of the Probate and Administration Rules. And for clarity, Section 67 provides that for the administration of the estate limited for purposes only of collecting and preserving the assets. Okay. If you read together with Rule 36 of the Probate and Administration Rule, it says that such letters can only issue where, owing to special circumstances, the urgency of the matter is so great that it will not be possible for the court to make a full grant of the presentation to the person who by law be entitled, okay, thereto in sufficient time to meet the necessities of the case. And still on the footing and to avoid any confusion, we have what we call grant ad colligenda bona defunct. Still the same grant is a grant that allows for collection and preservation of the estate of the deceased person, where the estate consists of perishables or assets which require quick action or attention. It is provided for under Rule 36(1) of the Probate and Administration Rules and is specifically on the collection of the deceased goods and preserving the same. Therefore, it could be seen that grant ad colligenda bona is intended to give the administrator power only to get into the estate of the deceased and to do such acts as are necessary in order to preserve it, and it is usually limited in this way. Okay. So it does not give a power to invest money collected in, nor to sell the assets even where a sale is necessary because the asset is wasting. Because it is anticipated that powers in this nature, if be required, they may be expressly included in the grant upon application being made to the court. In instances where the estate of a deceased person may be endangered by delay in administering it, the court is not bound to wait for an application by the person entitled to grant under the rules, but may grant letters of administration ad colligenda bona for the purpose of preserving the property. Therefore, it is settled law that a grant ad colligenda bona is meant to preserve a deceased estate and may be granted before a full grant is made, and that either a person entitled to a full grant or a total stranger who is concerned with the estate may apply to court for a grant ad colligenda bona. It is also quite clear that a grant ad colligenda bona cannot be issued to an individual where any life or surviving spouse or minority or minor children interest arises in an estate. That was the decision known as Tristram and Court's Probate Practice, a book. This means that Where any life or minority interest arises in the estate of the deceased, whether under his will or on intestacy, administration ad collegiana bona cannot be granted to a sole individual, and application should be made for the appointment of two or more individuals or a trust corporation with or without an individual. However, the appointment of a person as an administrator ad collegiana bona in respect of the estate of a deceased person does not include the right to take the place of the deceased for the purpose of instituting an action or suit, since there is express provision for that purpose in the Law of Succession Act. And even Justice Ringera was very categorical to say that ad collegiana bona cannot confer the grantee the status of the personal representative of the deceased person, hence he cannot administer the estate of the deceased person. But it is not okay to assume the applicability of grant ad collegiana bona, because we can see a 2021 decision, Korir Kipkurui, where the applicant had approached the court by way of a petition for special letters of administration seeking to access the deceased money from KCB bank account for the sole purpose of paying school fees, educational requirements, medical and maintenance costs for 3 children aged 12 years, 9 years and 25 years. The applicant submitted that Section 54 of the Law of Succession Act, as read with Rule 36(1) of the Probate Administration Rules, provide for limited grants, and that the exigencies of the situation required her to do so. Consequently, a grant of letter of administration ad collegiana bona was therefore granted to the petitioner for the purpose of solely making the withdrawal and payments of school fees for the whole year. Another application was seen where the deceased might be having rental properties, and it might be necessary to ensure the rental income is collected and not wasted by third parties. This was in the case of re-estate of Mary Wanja Wairimu 2017, where the court categorically considered an application for letters of administration ad collegiana bona, but this time under Section 67 of the Law of Succession Act. And one of the issues for determination was particulars of the rent the deceased collected, which was being wasted by the respondent. The court applied its inherent jurisdiction to order that pending the process of making of the grant in favor of the administrators, the following order as to the preservation of the estate was to abide: that a joint account in the names of both counsels to the succession cause, with the respect of the parties as joint signatories, was to be opened in a bank acceptable to both parties. And finally, by virtue of Rule 26 of the probate rules, it requires that any petition for issue of a grant must be accompanied by a consent duly signed by all persons entitled in the share of the same estate. What is a grant ad litem? One of the limited grants as to purpose. We have considered grant ad collegiana bona. Now we are in grant ad litem. It is granted to enable someone to represent the estate where the estate has been sued or intends to sue. This one never confuses students because it is a straightforward application. So before you can see various decisions that have applied this type of grant. What is grant pendente lite? Grant of a limited grant of pendente lite is provided under Rule 10 of the 5th schedule of the Law of Succession Act, which provides that in verbatim, pending any suit touching the validity of the will of a deceased person, or for obtaining or revoking any probate or any grant of letters of administration, the court may appoint an administrator of the estate of the deceased person, who shall have all the rights and powers of a general administrator, other than the right of distributing the estate and the administrator shall be subject to the immediate control of the court and shall act under its discretion. How have various courts interpreted this provision? In real estate of Kaur Sihar 2020, we are touching on issue of grant of limited grant pendelinte. It was held that it only applies where there is a will in place and its validity is in issue. Correspondingly, it is limited to the duration of the pendency of the suit. It allows the administrator appointed by the court to administer the estate until the action is completed as stated in that matter. Justice Moira in Estate of Onesimus Mwilu movie also reiterated that position because it says that it is limited in purpose in that it does not give authority to the administrator to distribute the estate, and it is also limited in time to the completion of the pending proceedings. Grant de bonis non administratis. It is granted where the representative has not completed the administration of the estate pursuant to paragraph 20 of the 5th schedule, either because he has died or for some other reason part of the estate has been left unadministered. This is limited to the purpose of administering the unadministered part that is left. Because if we see the case of estate of Anna Njoroge Njuki, the grant of letters had initially been made to the deceased husband, who subsequently died before completing the administration of the estate. Her son brought an application seeking the removal of the deceased administrator's name and its substitution with his. And the court directed that where an administrator dies and the estate is not fully administered, any of the beneficiaries entitled to the estate might file for letters de bonis non. And this was also similarly held in Faith Wanjiku Maganjo versus Ruben Murithi Maganjo 2017, where the court categorically stated that grant de bonis non are issued where the administrator dies and leaves behind an estate which has not been administered, because the second administrator will now be called administrator de bonis non and distributes the remaining assets. Now, at what instance will you apply for revocation of grant? Listen to this decision. An application before Justice Kamuni in the matter of estate of Mwangi Mugwe in the matter of estate of Mary Wairimu, the application should have been resolved by asking the applicant to apply for administration de bonis non. The applicant had brought a summons for the substitution of an administrator who died after the making of the grant, but before its confirmation. So the grant had been made, but before its confirmation. And the applicant, comes to court with a summons for substitution of an administrator. The court directed that there is no provision for the substitution of a deceased administrator under the Law of Succession Act and counselled the applicant to apply for the revocation of the grant on grounds that it had become inoperative and useless. This part is to be read with caution. If the facts of the examination will tell you that an administrator has died before the confirmation of the grant, you apply for the revocation of the grounds on the ground that the issued grant has become inoperative and useless. But if it's after confirmation, you go by de bonis non to administer part of the remainder. Cessante grant. grant of cessante. This is made when the original grant was limited as to time and that period has now expired, provided that the administration of the estate is still incomplete. So this is where you now want to extend time because it was limited as to time. So you move court according to paragraph 91 of the 5th schedule. Then there is a temporary grant by a resident magistrate under section 49. A resident magistrate grants this in cases of apparent urgency, and it is limited to collection of assets situated within its jurisdiction and payment of debts. It differs from the grant ad colligenda bona in that it is limited to collection of assets and payment of the debts of the estate and not collection and preservation of the estate. Its life is limited to 6 months. Grant limited as to property. This type of limited grant is made under paragraph 13 of the 5th schedule. It may be granted where a person dies leaving property of which he was the sole or surviving trustee, or in which he had no beneficial interest on his own account and leaves no general representative, or one who is unable or unwilling to act as such. Letters of administration limited to that property may be granted to the person beneficially interested in the property or to another on his behalf. This can be made under Rule 28 of the Probate and Administration Rules, where it categorically says that where the whole estate of a deceased person whose domicile is outside Kenya comprises of immovable property situated in Kenya. It may also be granted where a testator appoints executors only over certain assets in a specified area. Such executors obtain probate limited to that property. It is usually made in cases where the estate includes settled land or because the testator has chosen to appoint executors who are experts in a particular type of property to deal with that part of the estate. Domicility has arisen. There is a deceased person whose domicile is outside Kenya and comprises of immovable property situated in Kenya. This is one example where you will move court for a limited grant limited to that property. Limited as to time. There are several such grants that are provided for under paragraph 1 to 10 of the 5th schedule, and we have seen categorically section 49 of the Act that states that this type of grant is a temporary grant from the resident magistrate and will lapse after the expiry of 6 months. And it is different from colligenda. Okay? It is different because this is collecting and payment of debts. That is the trick that the examiner will look at. Then we are still under limited as to time. Grant durante autete minore. This is taken out where either the executors or the administrators are minors and as such are not entitled to a grant in their own right. A will may limit the time within which the representative is to act as an executor during the minorities of the testator's children. A grant may be made in the circumstances limited to the duration of the minority, and the grant automatically expires when the minor reaches 18 years old, unless some other time is specified by the court. So it is called grant durante autete minore. Then you have grant durante absentia, where the personal representative is outside the jurisdiction. The court may grant representation to another person limited to the duration of the absence of the personal representative. Good. Grant where will is unavailable. Where the deceased had made a will, but the same is lost, misplaced, or otherwise unable, either because the will is outside jurisdiction or held in a foreign court, Limited grant may be given until the original or more authentic copy is found or availed. Grant where will is unavailable, that is time. Grant durante absentia, that is tied to time. And grant durante artete minore, time. Then you have administration for use and benefit of a person of unsound mind, where a sole executor or sole universal or residential residuary or a residuary legatee or a person who will be solely entitled to the estate of an intestate according to the rule of intestates is mentally incapacitated, a grant of letters of administration will be made to the person to whom the care of his estate has been committed by a competent court, or there is no such person to any other person as the court thinks fit. So if there is a limitation applied to minors, there can also be a limitation applied to people with unsound mind. Then you have temporary grant limited to collection of assets and payment of debts. This is provided under Section 49 of the Law Succession Act and Rule 37 of the Probate and Admission Rule. It is related to the grant ad collegiata bona. The only difference between them being that the limited grant under Section 49 goes beyond collection of assets to cover payment of debts. It is made pending the making of a full grant. So that was the exact document that I was to share before you, so that you don't approach that examination with a rumor or in a situation where you have crammed various application of grants. So thank you so much for your participation. Catch up our next episode. Thank you.